Hi, today we're going to talk about how the assets are divided if your loved one died without a will. If your loved one didn't have a will, then whatever they own or whatever forms part of their estate will be divided among the closest family members according to something known as the Rules of Intestacy. The Rules of Intestacy set out which family members get what. And these rules vary from state to state. If you visit our information page, you'll be able to have a better understanding of the rules of intestacy that apply in your state. But I'll spend some time talking about some of the things to be aware of when reading the Rules of Intestacy. Under the Rules of Intestacy, the de facto partner or the spouse will generally have a significant entitlement to the estate. So it's important that you find out whether there was a de facto relationship established or not. And the other thing to bear in mind is that sometimes people pass away and they're separated but still married to someone. If that's the case, then it's highly likely that the estranged husband or wife is still entitled to inherit under the Rules of Intestacy. And if there's a situation that might lead to an unfair outcome, so for example, your loved one who passed away hasn't spoken to their husband or wife for a long time and simply didn't get around to getting divorced, then there is a process to change the automatic entitlements to inheritance. So there is a way to challenge the Rules of Intestacy if you think that it leads to an unfair outcome. The way that you challenge this is by launching a family provision claim against the estate. And there are strict time limits that apply in order to bring this claim. So it's important that you get legal advice quickly to make sure that any such claim is filed within time. Let's talk about children. Children also have a significant right to inherit under the Rules of Intestacy. Now, when we talk about children under the Rules of Intestacy, we are talking about biological or adopted children. Stepchildren do not have an automatic way to inherit under the rules. But if a stepchild was financially maintained by the deceased person, which means that the deceased person paid for the upkeep and welfare of the child, then that stepchild may be able to challenge the estate by commencing a family provision claim. Parents also have a right to inherit under the rules. Now, when it comes to the parents' share, if both parents are alive, they will split it. If only one parent is alive, then that parent will take the entire share allocated to the parent. Siblings. Brothers and sisters also have a right to inherit under the rules under certain circumstances. Now, it doesn't matter if it was a full sibling relationship or a half-brother, half-sister relationship. Both categories have the same right to inherit under the Rules of Intestacy. But stepbrothers and stepsisters do not have a right to inherit under the rules. If there are no brothers, sisters, parents, spouse, or children, then there are further family members that are entitled to inherit. They will be grandparents, and then aunties and uncles, and potentially also cousins. The way the rules work is that there are only a limited category or class of family members that can inherit if there is no will. Now, if the deceased person died with no such close family members, then whatever he or she owned will be given to the government. Another thing to understand about the Rules of Intestacy is how do you change the automatic Rules of Intestacy? Now, we've already talked about one way of changing this, which is challenging the estate and making a court claim under the Family Provision Act, but that can be stressful, costly, and complex. But if the close family members who are entitled to inherit under the rules of intestacy are in agreement, then provided everyone who's entitled to inherit is over 18 years of age, they can sign something called a deed of family arrangement to change the automatic right of inheritance under the rules. So for example, if you're in a state where it says that the deceased estate will be divided between the children and the husband or wife, then provided the children are over 18, they can agree to say, you know what, let mum or dad have the entire thing. Anyone who is under 18 years of age cannot give consent to change their allocation under the rules of intestacy. So it's important that anyone under 18 years of age, their share is not disturbed in any way and remains the same. But anyone who's 18 years or older can sign a deed of family arrangement to give away or change any inheritance they receive under the rules. Signing a deed of family arrangement is a common way that the rules of intestacy are changed by consent to make the arrangement more equitable and palatable for the family. To find out about the rules of intestacy that apply to your state, have a look at the table within the article below. I hope you've enjoyed this video. Subscribe to our channel for more information about what to do if you've recently lost a loved one.